reckon we're
Yes.
complete. Good. Well, I'm sorry you've got me again. That's because Margot is in hospital. And welcome to Eva Evans, whom you won't have met, but she's a survivor of many, many European conferences which she organized. This session is the rule of law and judicial independence. Are we speaking in this order? Okay, so first of all, Dr. Oliver Gerstenberg from UCL.
Good. Thank you so much for having me. And what I will present is a paper over which I have been agonizing a lot. I mean, but we all do that, as I suppose we agonize a lot on the question of what is and what should be the role of the Court of Justice of the EU as an exponent of the rule of law. And as we all know, the EU is a community based on the rule of law. And I mean, that is a statement which goes back to Walter Hallstein, but it was of course also by the Court of Justice. And the rule of law principle is, as you know, mentioned in Article 2 with the other values as a basis of, as values which are declared to be common to the member states. They are a basis of mutual trust between member states. And the rule of law is the glue holding the EU together as a peace project. Yet at the same time, as Article 2 stipulates these values, Article 4(2) of the TEU stipulates that the Union shall respect the equality of member states before the treaties, as well as their national identities inherent in their fundamental structures, political and constitutional. Now, the treaty does not draw a hierarchy between these two provisions. And the question here is, how can both these provisions be folded into a coherent ideal for the Court of Justice of the EU? For sure, the Court of Justice has been depicted as the epitome of a technocratic elite that deeply interferes with the national identity and displaces democracy by supporting overly broad interpretations that EU institutions give to their competences. And you all know about the ruling of the German Federal Constitutional Court, which dismissed as simply not comprehensible and a decision by the Court of Justice of the EU in the context of the bond buying program. However, while that dispute has been resolved pro tempore, the tensions between both articles are now dramatically being brought to the fore in the present political climate. The limits of constitutional tolerance in the EU are constantly being tried and tested by those governments and movements claiming nothing above outside the will of the people as their sole Grundnorm. And a vivid illustration of that, of course, are the judgments or the disputes about the conditionality mechanism before the Court of Justice concerning Hungary and Poland, where both these governments argued that the rule of law is essentially political and not legal in nature. So that is quite a nihilistic statement if you look at it, because it means that if true, the rule of law would just be an extension of politics. And so these two governments do not just challenge an interpretation of the rule of law, but the very principle itself. So the question is then, what can we say to countries like Poland and Hungary? Is the rule of law indeed just another partisan political ideology, or is it a framework that allows us to talk to each other across these divides? Against this backdrop, my paper argues that only conceptions, and I draw inspiration here from a formulation by Advocate General Kokot in the case on same-sex parenthood, to which I will come towards the end of my talk. This paper argues that only conceptions of national identity that reflect that are interpretively continuous with the framework values in Article 2 deserve respect under Article 4.2. The equality of member states before the treaties to which Article 4.2 refers is never just a raw interstate equality in a merely formal sense. Instead, the core framework values expressed in Article 2 serve as what I would like to think of as an overarching EU principle of legitimacy. Principle which not only provides normative justification for the primacy claims of EU law over domestic law, but also a litmus test for the boundaries of EU constitutional tolerance towards national identity claims, each imbued with historical experience and reflective of discrete democratic choice by the diverse member states. So in a first step, and of course, however, that statement just seems to kick the can down the road, because clearly the question is, we are here in the domain of the debate of thinness and thickness of the rule of law as a shared framework. So there are troubling questions. Should the rule of law be defined narrowly by focusing on judicial independence exclusively, or does Article 2 require a wider, more value-inclusive approach to the rule of law as a requirement of EU legitimacy and mutual trust? When it comes to the modern values of social liberalism on, say, gender, sexuality, multiculturalism, religious diversity, refugees, you name it, does the EU and does the Court of Justice have the authority to coercively impose those values on reluctant member states, which continue to embrace traditional values as part of their proclaimed national identities? Given the background of an EU that is divided into multiple demoi that are themselves internally morally divided, can the EU rule of law come to its own rescue and be mobilized ultimately by us, the citizens, themselves to win back hearts and minds in the civic democratic life of the EU? So in the next step, I address the famous sovereigntist objection or sovereigntist concern about the EU. So there is a tension between two ideas. On the one hand, member state in the EU, namely the voluntary subjection to the discipline of the rule of law, is for member states a way to protect and safeguard their democratic identities against democratic regression. So slightly loosely speaking, it's a policy against fascism, against lapsing back into fascism. However, at the same time, the EU and its legal order are also sometimes perceived as posing a threat to the very identities, fundamental structures, political and constitutional, of the member state, which EU membership is meant both to protect and to respect. So the question is, how can these two aspects be, which are in tension with each other, be brought together? And you all are familiar with these constitutionalizing statements by the Court of Justice about member states freely and voluntarily committing themselves to the common values of liberty and democracy in Article 2, the idea of a constitutional structures, the idea of a structured network of principles, rules, and mutually interdependent legal relations binding the European Union and its member states reciprocally, as well as binding member states to each other. So all these reciprocity enhancing words, and a constitutional structure. And finally, now on top of that, most recently, the idea that, and in response to the Polish and Hungarian nihilistic claim, that these values are not a mere statement of policy guidelines or intentions, but define the very identity of the European Union as a common legal order, and the European Union must be able to defend those values. So what do we mean by identity here? Is this a meaningful sentence? What drives us here? That is the question. So while there is this emphasis on identity, there is a countervailing element of that the EU and the Court of Justice act under politically constructed or within politically constructed bounds, namely those by the principle of conferral, and in particular Article 4.1, what is sometimes called the sovereignty clause. Competences not conferred upon the Union in the treaties remain with the member states. So that is the tension in the constitutional structure of the EU, which I would like to explore here. And there is a long literature here, which I just briefly referred to. Authors from Dieter Grimm to Joe Weiler to Giuliano Amato, all emphasizing that the legitimacy of the EU comes from the multiple demoi. So it is a derivatory legitimacy, and out of a concern that the EU doesn't really have a true constitution, although it speaks a language, but it doesn't have a true constitution because of its weakness in terms of democracy. So to speak of democracy, to speak of constitutionalism is quite a mouthful, according to these critics, among which is also the German Constitutional Court. Now, against that background, let us step back and ask, what can we mean? What do we mean by the rule of law? What can the EU rule of law mean? And here, let me start with a formulation drawn from Sir Francis Jacobs, namely that the ordinary laws, even those made by the sovereign, are subject to fundamental law and can therefore be held invalid if they transgress it. So if we start here, then we see there is there are more formal ways of reading the rule of law, more substantive ways if they include constitutional principles. And in substantive ways, the question is thin versus thick. And the upshot of this is, or let me put it this way, what do we mean when we speak of constitutional values and principles? What do we mean by saying it is constitutional? Well, the idea is that constitutions remove certain questions from majoritarian processes, from majoritarian contestation, and establish them as an overlapping consensus. But the argument is here that constitutions also have so that is a regulatory role, but they also have a justificational role that they allow us to speak to each other across our cultural divides with a shared framework. The idea of a framework of reference is one which Kohn-Lennertz, for example, uses. And so the assumption is that the idea is that although we can expect to sharply disagree among ourselves as we sit here about the wisdom of many laws and policies, we can still share this framework of reference. And of course, that is an optimistic assumption, which itself has been challenged. But the assumption is useful because it shows there is this dimension, this distinction between thinness and thickness. So we must not read too many normative ideas and wishes into the rule of law, because that would mean that we would read our opponents in discussion out of the rule of law. So the concern is here that there is a need for constitutional thinness. And I mean, that is something I can explain more later in discussion if need be. This is an issue which very strongly surfaces in the current US constitutional debate, which I think is useful here in this context. The final thing before I conclude is a brief reference to the case on same-sex parenthood in Bulgaria, which I think epitomizes quite nicely this idea of a framework which is sufficiently thin, in order not to block discussion, but thick enough in order to rule out ethnocentric prejudice. And this is a case about one of these small cases, which are always very illuminating. The VMA case, same-sex parenthood in Bulgaria, where Bulgaria simply says it's part of our identity, our national identity, not to change our family law. And family law in our country means husband, wife, and children, perhaps a dog as well. And so that is, but the possibility of two women forming a family and with a having a child, that is not part of our family law, and that we cannot accept that. Hence, we cannot issue a birth certificate. Hence, we cannot issue an identity card. Hence, we cannot issue a passport. However, the child had a passport in, it had a birth certificate in Spain, a Spanish one. So the Solomonic ruling here was that Bulgaria was obliged not to change its family law, but to legally recognize the Spanish birth certificate and on that basis then issue an ID and a passport. And the case is interesting in part for the opinion by the Advocate General, Kokot, here, who namely says that the limitation in Article 4.2 TEU to fundamental political and constitutional structures demonstrate that Article 4.2 does not simply refer to interpretations of the constitutional law of the member states, but introduce an autonomous concept of EU law, the interpretation of which is a matter for the Court of Justice. So the concept of identity is an autonomous concept. However, it is, by its very nature, it can only be determined, cannot be determined without taking into account the member states' own conceptions of their own national identities. So another way, to conclude with that, there is a dialogue here, and what this brings out is a justificational dimension of the rule of law. So the intention of this work here is to show that we can transcend the debate between thick and thin conceptions of the rule of law by emphasizing the proceduralizing justificational dimension of the rule of law, meaning it's a way of meaningful engagement with countries like Poland and forcing them into a justificational discourse.
Thank you very much.
Thank you.
Thank you. Then we go to Adam Lazowski from Westminster Law School on the independence of the judiciary as a condition sine qua non of EU membership. Adam.
Thank you very much indeed, and I'm very grateful to organizers for the invitation. Let's imagine we are in a courtroom. It can be anywhere. And we have one person who is being prosecuted, and judges from the bench are asking a question. And their instruction is, you have to answer yes or no. And the person says, no, I can't, my lordships. I just can't answer yes or no. But we are ordering you to answer our question yes or no. So, but I can't. So this is getting quite heated. And that person who is being prosecuted says, all right, my lordships, will you answer my question yes or no? Well, of course, yes, please proceed. Are you still accepting bribes? Well, we have two phenomena here, obviously. Independence of judiciary and corruption. And they are at the heart of EU pre-accession policy. That has not been the case throughout the 5 decades of EU enlargements. That became part of the menu, so to speak, only in sometime between 2004, the Big Bang enlargement, and 2007 enlargement. Why? Because it became quite clear to the European Commission and to the member states that the membership itself was not a magic wand that would fix all problems which emerged in the new member states, future candidates after collapse of different types of dictatorships. We had flavors of that kind of conditionality, rule of law based conditionality when Greece, Spain and Portugal were joining, but nothing of that sort as we witness now when we have witnessed for the past 20 years. So what went wrong? Dmitry Kochenov from CEU in his Kluwer monograph back in 2006, I believe, he argued that this was the failure of conditionality, that both enlargements, especially 2007 enlargement, were failures of conditionality, and the EU ended up being in a sort of in the corner with negotiations with Bulgaria and Romania coming to an end and the problems still persisting. So the decision was made to let the two countries in, not even trigger the membership postponement clause, and just see what happens. And that's when the Commission came up with an idea of cooperation and verification mechanism that Anna will be speaking about in a few minutes. But then already the negotiations were pending with Turkey, and that's of course a never-ending story, but also with Croatia. And that's when fixing the plane mid-air started. So the European Commission made attempts to reshape the pre-accession policy to make sure that we don't have the same experience as we had in 2007 with the future enlargements. But of course, the negotiations were pending already. Now, what changed them vis-a-vis Croatia? First of all rule of law matters became a separate chapter in the negotiation process, which sounds very technical and bureaucratic, but actually it makes a big difference. So a lot of attention was then paid to rule of law issues, independence of judiciary, just one of them. But then the European Commission was actually playing with its own legitimacy, because it was adding benchmarks and conditions as the negotiations were pending. And some of those benchmarks were, let's call it a spade, totally unrealistic. Just to give this argument merit, they asked Croatia to build, and I quote, solid track record of anti-corruption investigations and prosecutions. Deadline, 1 year. Well, exactly. If you ask colleagues from Croatia, how did they manage? They will all tell you, we just arrested our prime minister, which actually they did. He was a very corrupt person. And that sent the signal to Brussels, okay, they take it seriously. But of course, Croatia was a work in progress. So what we have now is a result of, in terms of pre-accession policies, a result of two things. Well, first of all, proper reform of pre-accession policy, at least instruments, tools, and the way it is implemented, but also the rule of law crisis in the European Union. The problem at some point was that the EU was using a lot of conditionality and benchmarking vis-a-vis non-EU states, even those that at the time were not expressing a desire of becoming a member, see Ukraine and the story of their association agreement, but was not doing much internally. When Hungary was stepping on the wrong path and then followed by Poland. And actually the Court of Justice was very instrumental here with the very famous judgment about Portuguese judges, where you read the text and at some point it's obvious that this is no longer about Portugal. This is actually more general. I actually have it scribbled on the copy when I was reading, said this is no longer about Portugal. This is an invitation to the European Commission to trigger infringement procedures. So that was basically the reaction in many countries. I'm sure it will be confirmed later, for instance, in Albania, where both politicians and specialists were saying, well, the EU is proceeding under do as I say, don't do as I do principle, with all those benchmarks applied in conditionality externally, but not much happening internally. Now, why does it matter? Well, obviously, it does matter. We've heard this morning from several speakers that rule of law matters, and this is a very important thing. But looking through the lenses of the European Union, it matters because this is not a golf club. It's a legal system where law of the European Union is supposed to be applied by independent judges. And it's a system which in many areas is built on mutual recognition, starting with free movement of goods and famous Cassis de Dijon judgment, going through recognition of qualifications, criminal matters, judicial cooperation in civil matters, you name it. So it matters a great deal that countries which join the European Union respect the rule of law. They have independent judiciary. And of course, the fear is that things may unravel when they are on board. And Poland and Hungary, sadly, are very good examples here that reforms can be dismantled very quickly. So has the EU learned the lessons? When it comes to the pre-accession policy, at least when it comes to whatever is on paper, it has. Pre-accession policy is a completely different beast now. And a lot of rule of law benchmarking and conditionality. You have independence of judiciary there, but also corruption, everything else. It starts to apply at very, very early stages. And we're going to hear a paper about Albania, which is a very good example where all those benchmarks or priorities, as they were called, were set first for Albania to become a candidate country, to be upgraded from potential candidate to candidate, and then to start the negotiations. And those benchmarks have been in place for the past 14 years, if not more. The same now we are witnessing same method being applied to Georgia, which applied for membership literally 2 days after Ukraine did, and Moldova as well. But Georgia has lots of rule of law issues, and therefore it is for now a potential candidate country. So rule of law benchmarking pops up straight away when the country actually expresses a desire of becoming a member, has, for instance, association agreement, and definitely when it applies for membership. Then similar benchmarks or new benchmarks kick in when country wants to start the accession negotiations. And we've heard from Professor Petrov that Ukraine has met 2 out of several priorities. I will add to what Roman has mentioned that the European Commission noted progress in the other areas as well. So it's not that nothing has happened, but it's a work in progress with bombs landing on the heads of civil servants, government, parliament. So these things are not easy. Country functions, the public administration functions, the parliament functions. No one knows where and when they meet for obvious reasons, but they're doing a lot of work. So once the negotiations start, chapter 23, as it's called, rule of law chapter, is part of the first cluster of chapters that are to be opened. And the cluster is called fundamentals, not accidentally. And the thing is now that this is the first chapter to be opened, the last to be closed. So here, the European Union is all the time putting pressure on the candidates to proceed with reforms, to make them real, to implement those reforms. And it is a bit like in Chekhov's play that someone in act first will put a gun on the wall and it'll be there throughout. Maybe someone will use it. So it's a bit like this. Now, what about the accession negotiations themselves? What happens? Because accession negotiations take years. What happens if we have some reforms in place and then we have the backsliding, which sometimes is tempting for those who are in power? Well, the general mandate for negotiations with Albania and North Macedonia is a very good example how these things work now in the pre-accession policy. So in 2 points, bearing in mind the limited time, the EU has the right to suspend the negotiations altogether if there is rule of law backsliding at any point throughout the negotiations. Furthermore, if there is progress in other clusters, say internal market, but not much in cluster 1 fundamentals, again, negotiations may be frozen. And they may be reopened subject to additional benchmarks, additional conditionality. So the EU is keeping finger on the trigger throughout accession process. Now, what about the accession itself? Here, we have another development that is very important that has come from the Court of Justice, which is the Republika judgment, which was not for once a rule of law judgment relating to Poland or Hungary, but Malta rather, where the court, according to some, created the principle of non-aggression. According to others, including your humble servant, the court has codified the principle that has been in place anyhow. Basically meaning that once countries join, as a matter of principle of EU law, they cannot indulge into backsliding. This is a gift to the European Commission, I suppose, because it can be then used in infringement cases against such misbehaving member states. But we have actually other tools, I would say traditionally since 2004 enlargement, that have never been used. Safeguard clauses, accession treaties, 2004, 7 and 11, had safeguard clauses allowing the European Union to suspend certain instruments of EU law, for instance, mutual recognition in criminal matters instruments, if there was backsliding and if that happened within 3 years of accession. Now, what happens then after the accession, apart from safeguard clauses? Of course, now with the experience of Poland and Hungary, we know very well that we have the traditional set of tools, the infringement procedures that can be used by the European Commission. That may lead to penalties. Now, the system is not perfect and needs a reform. Why? Because under Article 258, which is the first procedure, the only thing that the court can do in rule of law cases is to declare a member state to be in breach. Only then Commission has to bring another case to 60 for the penalty to be imposed. And for me, something is on its head. If in rule of law cases, this is how it looks, but now the court can impose a penalty under 258 if a member state fails to transpose a directive on hens laying eggs, because it's a legislative directive, and therefore the combination of Article 258, 260 paragraph 3 allows the court to impose a penalty first time round. For me, there's something wrong that for a relatively benign breach of EU law, you can have a penalty. For a flagrant breach of Article 2, you can't have the penalty first time around. You need to go through the full cycle of 2 infringement procedures. And the final point, and I'll go back to what Professor Petrov mentioned. Ukraine has been asking for fast-track accession, which obviously it's very difficult. It's a very difficult proposition to be entertained. But the trouble is that enlargement, once again, with the Russian invasion of Ukraine, has become a geopolitical issue. And if you ask me, I would argue that we need a fundamental change of paradigm. We need to have fast-track enlargement, not only for Ukraine, but for Balkan countries and Moldova, possibly Georgia, subject to very long transition periods, exceptions. So for instance, transition periods for mutual recognition in criminal matters, and subject to longer than 3 years safeguard clauses to make sure that the EU has full set of tools to address deficiencies should they arise. And as we've learned from Poland and Hungary, sometimes member states may misbehave very soon after the accession. That was Croatia. The moment the EU has warned them that they will trigger safeguard clause, problem was solved. Or, as in life, you can have problems with teenagers, like Poland and Hungary, the teenage member states. Thank you.
Right, thank you very much indeed. Now we go to the debate between Luxembourg and Strasbourg with Dr. Barbara Grabowska-Moroz from the CEU Democracy Institute.
Thank you for the invitation. When I was preparing for today's meeting, I realized that I've been in London the last time on 31st of January 2020. And I was 8 months pregnant. I was in exactly the same room during Reconnect conference. There are plenty of reports and deliverables after this conference. We're discussing rule of law conditionality as an option for the EU. As you can imagine, a lot has changed since then. When I left, Brexit happened. Then the pandemic, meaning the world really changed. My son was born and he learned new words. The last one is awesome. And there are plenty of new rule of law developments since then. And those developments are not awesome. And I want to discuss and concentrate only on one of the aspects of those developments, meaning relation between Strasbourg and Luxembourg, and also taking into account this notion of time, how much has changed and what has not changed at all since last few years. So as Professor Lawson mentioned in the very beginning, Strasbourg court was fast and not really that fast when it comes to rule of law crisis, especially in the Polish cases. In 2020, the first rule of law judgment was not even delivered yet. There was another year of pending case when Xeroflor was decided by Strasbourg. So the very basic of the whole crisis, the tribunal, captured tribunal, became to violate the convention, was decided after 6 years since the crisis started. But Luxembourg has not ruled that at all. There is no constitutional tribunal case in Luxembourg court. Yes, the commission announced they're going to introduce infringement action, but the case has not reached court yet. And interestingly, the Court of Justice does not refer to Strasbourg ruling in Xeroflor, almost in none of the cases. Some of the cases, when in the Advocates General opinions, yes, they do refer to Xeroflor, but the court somehow does not. Of course, the Strasbourg development of the case law, especially in the Polish cases, it was based on Astradsson case, so this Icelandic case about legality of judicial appointments, and this criteria of tribunal established by Lobos, really creatively developed by Strasbourg and by Polish cases. Luxembourg went different road, so they reinvented Article 19. Interestingly, they much more refer to Article 19 than to the Charter and Article 47. Somehow the treaty seems to be a stronger element, and this requirement of effective legal protection seems to be a driving force in this case law. But as I mentioned, I think they've tried to avoid Strasbourg court. And from the perspective of infringement actions, that could be perceived as, a different methodology. Strasbourg rules case in a different way. In this Astradsson case test, they have to look whether the domestic law was violated. So they have to get to interpretation of the domestic law, which is, I think, a very tricky thing for international court. But that's how they do the business. Luxembourg goes a different way. They mostly refer to their own standards, to Article 19. So they try to avoid, they can avoid Strasbourg court. And it can be okay with infringement actions, but I think it can be really dangerous with preliminary references cases. And I want to concentrate on just one case, which was decided last year by the Court of Justice. I commented on this case in the latest issue of Common Market Law Review. So this is product placement part. I strongly encourage you to take a look in this very last issue. That was also Banco de Santander case law analyzed by two scholars. And I think that in that case, this Getting Noble case, I think it shows what can happen when Luxembourg ignores Strasbourg. Just to give you a small background, one of the judges appointed to the Supreme Court was found to be a reason of violation of Article 6 of the Convention. The case was called Advanced Pharma. So the judge was in the bench who decided the case in the Supreme Court, and the Court of Human Rights decided that the fact that the man was unlawfully appointed, it violates the convention. It happened that a couple of years later, the same judge referred a question to the Court of Justice to ask about how to check the independence of judges, but those who were appointed before him, before 2018. So he tried to engage the Court of Justice in a kind of dialogue about judicial independence. And the commission was not even sure what to say about the admissibility of the reference. So they said it should be admissible. The Polish government, of course, did not object. The only institution who was presenting possible shortcomings of independence of this person was the Ombudsman Office, the Polish Ombudsman Office. However, the Court of Justice found the reference to be admissible. So they decided to engage into dialogue into unlawfully appointed judge who's already being in a bench in a different case violated the convention. And there were various arguments presented both by Advocate General Bobek and by the Court of Justice why it's admissible, why we should discuss judicial independence with unlawfully appointed judge. But the main element of this ruling is a presumption of judicial independence in the context of preliminary reference. I think it has a lot of negative consequences for the Court of Justice. First of all, they just ignored the Strasbourg ruling. Second of all, I think they dissolved their own case law, which was based on Banco de Santander ruling from 2020, if I'm correct. So they basically said Article 19, with all those effective judicial protection, does not apply to proceedings based on 267. And as a result of that, I think the Bosphorus presumption can be also harmed by such approach to preliminary reference. From the domestic perspective, such a ruling legitimizes unlawfully appointed judge, which of course brings another huge question about possible transition to democracy in case of any political changes that might happen one day in Poland. As a footnote, Advocate General makes a couple of interesting notes how to make this transition, what are the red lines that we could do in transition to democracy. Again, the Court of Justice does not discuss it at all. Advocate General Bobek refers to Xeroflor and he gives a hint. I'm not really sure whether the tribunal in Poland is independent. The Court of Justice does not say anything about it. I think it might be an example that the Court of Justice is somehow closing towards Strasbourg case law, and this might be a very dangerous development. What might be extremely interesting is what will be the reaction of Strasbourg Court, how the Court of Justice, Court of Human Rights is going to react on this type of cases in case of, if such case will be brought to Strasbourg. Also, this debate about European arrest warrant cases, when one of the domestic court questions the independence of the Netherlands Independent Court, that might be also interesting to see how the Court of Human Rights is going to react to such developments and whether the standard of independence in those cases is correctly balanced. But since I don't have more time and I don't have good answers, I think that will be a topic for the next London-Leiden conference. Thank you.
Thank you very much. Keeping going on, Dr. Oana Stefan from the Centre of European Law at King's on judicial independence in the Romanian case.
Thank you very much. Thank you very much for inviting me. It's a pleasure to be here, and also it's very good for me to get me thinking on a very much work in progress paper that I have on the Romanian cases. And now, disclaimer, I am both Romanian and also worked on the accession back in 2004, 6, and so on. Now, and also, like, why do I write about this is because I only hear around myself a statement such as Romanian cases are tough, or only Bobek understands Romanian cases, which is partly true, but I also find other advocates general do a pretty good job at it as well. Now, what I would argue is that Romanian cases are simply different. And I would like to cite the French president, Raymond Poincaré, who said, "Nous sommes ici au port de l'Orient où tout est pris à la légère." Basically, we're here at Orient Gates and everything is taken lightly. So that's Romania for you. Now, this is a contextual point. So one of the reasons for which we are different and the Romanian cases are different is contextual. And brings back the point that Adam made about the interplay between corruption and independence of judiciary. And I'm very, very happy that the Principles Project is also taking the corruption point very seriously. Because I think we are a bit different than the Polish and the Hungarian cases. I mean, obviously, correct me if I'm wrong on that, because we start from a point of heavy corruption, which leads to a lack of independence of the judiciary. Now, back in 2004, we had wonderful reforms pressured by the European Union, 2 laws on the independence of the judiciary, which were amazing, and which reported on to the European Commission on the 2 overlapping chapters between independence of the judiciary on the one hand and anti-corruption, which are also shared between 2 ministries, the Ministry of Justice and Ministry of Interior, which, as Adam pointed out, brought only problems and difficulties. So we reported on this, everything was fantastic on paper, but there were a lot of problems with implementation. And this is when corruption comes into play, because obviously if you have a corrupt and captured council of magistracy and you do not have the judges to put in those specialized anti-corruption courts that you set up, you are in a very bad situation. But however, we were, pushing through these reforms, and they went on forever, like, for 10 years at least, up to 2017. And in 2017, something happened, and we started reversing all of the things because the corruption was still endemic in the system. So in order for people to get a bit more of the cash that they were used to, they basically changed the system, right? So, I mean, if you remember all the Berlusconi cases about, changing the legal system in order to benefit from a more lenient penal system and so on, this is exactly what happened. And all the things that you're hearing about, the interim appointment of chief inspector to the judicial inspectorate, everything you hear about the a section with special powers that we don't really need to investigate corruption in courts, the system of liability of magistrates, all of this is about the same thing, getting back to, being able to do things in the good old way. So there are quite a lot of reforms done that are contested now through preliminary ruling in front of the courts back in 2017, 2019. And they were adopted basically during the night. There were a lot of people on the street and so on, but nobody cared really. And they continued being into play. So this is one of the reasons. I think we're starting from a corruption point here. And the second reason for which we're different is a legal, more of a legal problem. And on this, it's a bit more close to heart because what I am doing is new governance, soft law, that sort of thing. So let me take you to that route as well. So back in 2004, again, we sent the reports to the Commission. We love it. We're great. We want to be in the European Union. It was clear to everyone in these ministries, Interior and Justice, like the little people, the civil servants, that we were not going to get in. However, the news came from Brussels that yes, we're in, we're a go for 2007. The price to pay is we have this cooperation and verification mechanism that Adam mentioned, whereby, you have to just report every year on what progress you have made, because obviously you still have some progress. And now this was adopted on, it's basically a Commission decision that is adopted on the basis of the accession treaty of the Romania and Bulgaria as also, because both countries were subject to the same rules. And the procedure is as follows. Each year, Romania submitted a report. I say submitted because this was just last year to try to integrate us into Schengen. Well, that went very well. So each year, the Romania submits this report, and then the Commission would come back and submit another report to the Parliament and the Council. And in that report, it kind of sends also recommendations to Romania. Now, this is something that is, quite usual in European integration. You have this new governance system that talk a lot about dialogue. So we spoke about dialogue quite a lot today. We're trying to engage member states into kind of getting to a common ground. But everything relies really on soft law, right? Because these reports are not legally binding. People cannot necessarily be held to account, especially since we are already inside the European Union and we do not have all of those guns that Adam was talking about. So the argument of my paper is that these mechanisms, these soft law mechanisms, might be appropriate in certain cases, like I don't know, state aid, competition, administrative cooperation, and so on, but they are not appropriate when dealing with values. And this is relevant because we see a flurry, really, of these type of instruments that apply now to the members that are backsliding and so on. So Romania and Bulgaria were somehow subjected to these new governance mechanisms since the very beginning. Now, why are they not working? I mean, first of all, one little point. They might not be working to, redress the rule of law problems, but they work in a certain way, and to this, they have a bit of a post. They fuel litigation. So all the Romanian cases that we see in front of the courts are preliminary references that are based on these verification mechanism reports. Because you have a lot of, organizations, the Association of Judges, and also prosecutors, they have an organization who, of course, empowered by judgments such as the Portuguese judgment case, the judges case, and so on, decided to take to the Romanian courts and demand preliminary references to be sent to the ECJ. And these preliminary references were sent on the basis of the point, well, we are now regressing. We are asked to be progressing here. So another difference in the Romanian case is that we do not have necessarily this non-regression principle, and I really agree with you that it's not necessarily something new for Republica, but we have a progression obligation that the Court of Justice is asking for us in a couple of cases. So these associations went to the courts, asked these preliminary references to the European Court of Justice, and we have, I think, over like, I don't know, 20 now. I stopped counting, I think, of these preliminary references. They were classified in 4 series. The first series was this principle of progression, which is Asociația Forumului Judecătorilor. Then a second wave looks at the primacy of EU law and the fight against corruption. A third wave about the clarification of the Romanian Constitutional Court's power to tell actually judges what to do. And the fourth waves, which is coming right now, it's about the promotion of judges and the rules on promotion and how they can mess up with the rule of law and judicial independence. Now, all of these cases bring to the fore the shortcomings of the cooperation and verification mechanism procedure. And there are 3 shortcomings here. First of all, the non-binding nature of the reports. And these reports being non-binding means that, they cannot be imposed on the national courts, and especially the big elephant in the room on Romanian Constitutional Court. A national court, the European Court of Justice said a long time ago in Grimaldi that national courts have to take into account these soft law instruments whenever they judge on cases. We know now from Asociația Forumului Judecătorilor, the Romanian case, I was very happy that this is actually an obligation based on the duty of sincere cooperation. The court never spelled it out, it just spelled it out in this Asociația Forumului Judecătorilor. However, tough luck, the Constitutional Court of Romania could not simply give a damn about it, right? Because 2 days after the Asociația Forumului Judecătorilor, the Constitutional Court of Romania went with a, big judgment out there saying, national courts, you should not look at these reports, they are non-binding, and it is kind of outrageous for the Court of Justice to ask us to act and to progress and so on in accordance with these reports. Now, obviously, this is stating the obvious reasoning there. These constitutional courts can pervert various arguments that are put forward by the Court of Justice in order to fuel illegitimate claims and power grabs by the institutions that is capturing the Romanian Constitutional Court. Now, there is a second reason for which these non-binding instruments are not useful, and this is because soft law is essentially an instrument of dialogue. Now, if you manage to get into this kind of perverted rhetoric with the Constitutional Court of Romania saying this is non-binding, the Court of Justice is saying it's just a duty of cooperation. So we are cooperating, we're looking at it, but we don't do anything with it. Then you cannot engage in a viable dialogue between this level of governance. So I don't think it is the right way to do. And the third reason for which these soft law instruments cannot work is because their purpose is to manage diversity in this mess that is the European Union, right? With all of this multi-level governance system and so on. But there is no diversity when we're talking about judicial independence, is there, right? Because, obviously, we can talk about values and so on, but some of them are, as Oliver was saying, kind of fundamental. So I don't think, again, you can, why should you have software in order to manage this type of diversity? Now, obviously, since there is no hard law, and obviously the return is, the solution would be returning to hard law and big guns, we have this reliance on, obviously, this quest, if you want, of the Court of Justice for this autonomy of European Union law, talking about combining Article 19, Article 2 of the treaty with Article 47 of the Charter, and deciding that all of these reforms of the Romania are wrong, not only because of the reports, but also because of the articles of the treaty. And obviously, we can discuss about the contestation about the autonomy and so on. We see a lot of the arbitrage cases like Comstroy mentioned in all of these Romanian cases. So everything is connected there, right? So right now, I don't have any solutions except that, this is completely, soft law is completely inefficient and can lead to the annihilation of hard law. In this particular context. Let's not forget also the conditionality regulation, which was basically put on hold for years, right? Because we were waiting for the Commission to issue soft guidance for application. But just as a, as a footnote, the cooperation and verification mechanism was stopped at the end of last year in the attempt to integrate Romania into Schengen. And curiously, this happened on the backdrop of the Commission saying there is progress a couple of days after the decision of the Romanian Constitutional Court denying primacy and so on. And finally, the cooperation and verification mechanism still pops up in all the preliminary references, the latest one being from this month, I think, on, promotion of judges and so on and so forth. Thank you very much.
Thank you. And then to conclude, Yolanda Becherai, our own representative from the Bingham Center, on this topic of her country, Albania.
So we've heard until now the challenges and the perspectives of existing member states. I wanted to discuss here at the end of this very diverse panel, the perspective of the candidate country. What are the challenges and how effective the steps that are undertaken are in practice. It was mentioned at the beginning of this panel that what has driven many of the reforms in this field is the importance of ensuring independence of the judiciary, but at the same time fighting corruption. Well, that is a clear leitmotif in Albania's judicial reform most recently. So in October 2014, Albania initiated a comprehensive justice reform process with the aim to ensure an effective system of checks and balances and to introduce anti-corruption measures. And since the beginning, it was clear that the objective, or at least the reason for introducing those changes, was the ultimate aim of becoming a member of the European Union. So it was very much a EU membership-driven process. So the process, not surprisingly, coincided with the European Commission progress report on Albania, which showed that there are important key priority areas, particularly public administration, judicial reform, fight of organized crime and corruption, the strengthening of the protection of fundamental rights that need to be addressed before even starting the dialogue, as Adam already mentioned at the beginning. So in response to that, the objective of the justice reform was, and I'm quoting, to address the shared perception of Albania lacking an independent, accountable, and efficient justice system. So this was the main challenges to be addressed. And the vision of the reform was to restore confidence in the justice system through an in-depth process of constitutional, legal, and institutional change. So not just the rules, but also the institutions, and so from paper to implementation, address the whole process, the entire process. And this was, of course, then backed and acknowledged by the Commission, that recognized that both by the Commission, but also at the level of the Council of Europe, by the Venice Commission, that assisted closely Albania in the reform of those rules. And in the words of the Venice Commission, a comprehensive reform of the Albanian justice system is needed urgently, and the critical solution in this field, critical solutions in this field require radical solutions. So what are these radical solutions or radical measures that were taken in Albania? First of all, as I mentioned, constitutional change. Constitutional change in 2016, the Albanian constitution was profoundly changed. 1/3 of the constitution was modified. 1/3 of the provisions of the constitution was changed, including the the provisions for the establishment of new independent institutions, of governance of the judiciary and the prosecution system, as well as other independent institutions. The second element, so legal change, was reflected in the adoption of more than 30 core laws that were reflecting the same principles of judicial independence, so reducing the capture by government of judicial institutions, and fighting corruption and organized crime. And the third element, institutional change, I already mentioned, these constitutional and legal changes provided for the establishment of new institutions in order to ensure integrity, accountability, and efficiency of delivering service, delivering justice. So the criminal code, criminal procedural code, administrative court law, etc., were also profoundly revised and modified. Let me briefly mention 3 core independent institutions that were established. They didn't exist before, or at least not in the same shape, which reflect some standards that were developed, especially at the Council of Europe level. An independent body for governance body for judges, a body that has the power to promote judges, evaluates judges periodically, so their performance, and is independent from the government. Its membership is half judges and another half lawyers, academia, and civil society, but no representation from the government as it was before, or from political bodies. The similar body for the governance of the prosecution system, so for prosecutors. For the election of judges of the higher courts, constitutional court or the high justice inspector, which is this independent body that undertakes investigations and then decides on disciplinary measures that affect judges or prosecutors. In these cases, since these are under the Constitution positions that where political institutions have a say, for instance, for constitutional court judges, it is one third of the judges are elected by the parliament, 1/3 by the president, and 1/3 by the high court. In these cases, another ad hoc body was established, independent, that pre-vets, let's say, pre-selects the candidates, and only sends to these bodies a list of 3, which ensures a balance between the right of these political bodies to choose a candidate, but also fairness, independence, and impartiality in the selection of those members. So these are just 3 examples of the new institutions that were established, and they have been working now since 2018. But a unique feature, the real unique feature that reflects the wording justifies radical solutions in that quote of the Venice Commission, is this, I'm sure most of you have heard of it, it's the vetting process. It's called transitional reevaluation process of all sitting judges and prosecutors. So since one of the main aims of the reform was to eliminate corruption and influence from the government, the idea was, let's start from 0. All judges and prosecutors will be vetted. They will undergo these checks. There are 3 checks: financial, connections with crime, and so with organized crime, and then a professional evaluation. But basically, until now, almost all judges, with very few exceptions, 1 or 2 judges, I mean magistrates, so both judges and prosecutors, have passed the 3rd test, but many of them have failed the 1st and the 2nd. So inability to explain reasonably the assets that they have based on salaries or previous ownership of immovable assets, or connections with organized crime, influence from external influence, etc. So in terms of numbers, so another element of this is institutionally how this works. It's three bodies that are institutions that are involved. First, it's called the Independent Qualifications Committee. So it's but they are not judges. They have established through a process of selection by the parliament, and they make these assessments. So first instance, then there is a second instance, which is a specialized chamber at the Constitutional Court that decides on aspects of legal aspects, aspects of that have to do with the legal procedure as a second level. And then there is the so-called independent commissioner. Once again, an independent institution that may request cases to be appealed or to be heard by the appeal chamber in case they are not convinced by the decision of the first instance. And at the same time, and all these are national, so are Albanian citizens that sit in these three organs that I mentioned. But on the side of that, there is the monitoring, the international monitoring operation, the IMO. It is composed of internationals. They don't have a decisive power, so their decisions are not binding, but they exert a quite important role, sometimes backing the position of the commissioner, saying yes, the decision of the first instance wasn't that maybe lacked independence, or you have to think that Albania is a very small country, so everyone is related to someone else. So there is a high risk that even without going into a political influence, you get influenced because you might be very close to someone else, and because of the citizenship and such. So because of the limited number of citizens in general. So that's I'm trying to explain the balance between what nationals, the role of Albanian citizens, and this monitoring role, but not decide. So an organ with a body with that has a deciding mandate in this case. So a few statistics. Between February 2018 and March 2023, the Independent Qualification Commission, so the first instance, handled about 630 cases out of 800 subjects of reevaluation. So there are about 800 between judges and prosecutors and high-level officials to undergo the vetting system. And only about 43% were confirmed in office. So less than 50%, so more than 50%, almost 60% at least until now, have left the system either of their own choice, because that was also given, but that's a choice that if voluntarily taken means that I don't want my assets to be checked, basically, because I know what the outcome is. And then the other part is they decided to test the system. They went through the procedure and they failed to, so they were yes, so their mandate terminated because they didn't pass one of the checks, or all three of them, or at least two of them. So what is the impact of this? So we start from the idea that the country is committed to introducing all these measures that are checked and are validated by the Venice Commission, by international organizations as necessary in order to have a system that complies with the rule of law and then is that they can rightly start on an I wouldn't say completely equal, but on a peer-to-peer basis, the discussions with the European Commission. But you have all these side effects, important negative or at least dangerous side effects, because the reduction of the number of judges means an increase in the backlog, means an extended time for the solution of cases. And I see I have enormously exceeded my time. So I just wanted to conclude. This was just to give you an overview of what is happening. But while you can see the complexity of introducing such measures that are rightful and legitimate and have obviously a positive aim, something else that was also challenged was whether these vetting bodies themselves, they complied with the requirements of an independent and impartial judiciary. And for these cases were decided by the European Court of Human Rights. There are now at least 2 decisions, even more, but 2 important decisions. One saying that yes, these bodies, these institutions comply with the requirement of independent and impartial judiciary, even though they are not judges as such, as I mentioned. And the other important, most recent decision from a couple of months ago regards the fact. So what happens if one of these members of these vetting bodies is found to have been nominated there by violating some of the procedural rules? What happens to the cases that were decided by him or her? So more for the next time, for the next conference or during the discussion. Thank you very much, and apologies for taking.
Thank you very much indeed. Now we've got half an hour. Half an hour for questions and discussion. So who would like to start? It's not excluded that members of the platform ask each other questions. Yeah, over there.
Thank you very much. Eva Żelazna, University of Leicester. Thank you very much to all the speakers for very interesting interventions. I have a question for Dr. Grabowska-Moroz. I was wondering whether the Court of Justice of the European Union would have had to apply or consider standards for judicial independence in a different way in the context of the preliminary ruling procedure if the EU was a party to the European Convention on Human Rights, and whether the fact that the court didn't mention or didn't follow the jurisprudence of the Strasbourg Court in the recent case that you mentioned, whether that tell us anything about the prospect of the European Union acceding in the near future.
I could just shout. I have a very loud voice. I know, but oh, sorry. I'm so sorry. So sorry to the Zoomers. No, briefly, I wonder if the panel could just reflect on say, the likelihood of seeing enlargement of the EU in the next 5 to 10 years, especially considering the internal political situation. Sorry to the Zoom.
Any more to start with? So, yes,
I have a question. I have
you've got a question.
Yeah, to Anna, because you mentioned that 4 judicial associations in Romania initiated proceedings before the Court of Justice. And that was not the case with Poland. There is no case initiated by the association, by members, yes, but not association as association. So my question would be whether judicial associations are important rule of law actors in Romania in dealing with this domestic mess.
Okay. Right, who would like to start? You answered that.
I have a question.
Well, you put a question.
Can I?
Yes, please.
So I was wondering what happens with, the 60% of the vacant posts now?
Right. So let's start. No more questions from me? No, so would you like to start?
Yes.
Answer?
Yes, thank you. I have a few comments, and then I will give an answer to the question about the prospect of future enlargements. You've mentioned that these reforms were accession driven, and that is true not only for Albania, but also for other countries which are queuing currently for EU membership. And we need to, I think, see a much bigger picture, because what we're dealing with, especially when it comes to former Yugoslav countries, but to an extent also with Albania, accession is also state creation exercise. You've mentioned new institutions being created. And that, of course, is tough. That takes time. And a societal change is required on the top of everything else. And that's even more so if we bring into the equation Ukraine, Moldova, and potentially Georgia. Because, well, maybe Belarus one day. Lukashenko has run away to Turkey today, so maybe the beginning of the end of the dictatorship there as well. In their cases, it's not only state creation exercise that it's going to kick in now properly, even though it's been 30 years of independence. But more importantly, it's the de-Sovietization. I mean, this is the moment when Ukraine is properly cut off from its Soviet past. And we need to remember, going back to the societal change, that we were dealing here with Homo Sovieticus, brains wired, screwed in a completely different way, which we can see in Russia, for instance. So it's a massive exercise. Yes, we're ticking boxes here, but we're also dealing with state creation exercise, and we should not forget about that. It was different with countries like Poland and Hungary or Czechoslovakia, then Czech Republic, Slovakia, or Romania. They were satellite countries of Soviet Union, influenced by Homo Sovieticus, but they were not part of the system from within. Now, with the vetting process, this is actually also going to Joanna's question. I think the whole experience of vetting in Albania, it should be a warning to the European Union above all, handle with care, because if you push too much with conditionality, you end up having courts empty, which is what happened at some point. There were some courts which were pretty much empty, which in a small country is a huge problem, because how do you fill those posts again? How you make the judicial system function again? This was, for me, a different way, failure of conditionality. Now, as to the future accessions, I think the key thing is whether the key member states understand that the next enlargement will be a geopolitical exercise. Because we are at a historical moment, let's face it. And if we do have the big accession, this will have to be done subject to all those longer transition regimes, verification mechanisms, you name them. The big elephant in the room will be the institutional reform for the European Union, because the only kind of enlargement I see is the Comet enlargement 2004 2.0, basically. So you have one big country and then the rest joins in. So here you have Ukraine and the Balkan states, Moldova, potentially Georgia. And that, of course, means that potentially the number of member states may go up even to 35 or more. If we look back at history of 2004 enlargement, everyone was saying this is not going to work. This is going to fall apart because there'll be too many member states. It does not. And I don't think it will if we have such a big bang enlargement. But big things will have to be addressed. Size of the European Parliament, size of the Commission, mean, with 27 commissioners, some have very limited portfolios because there's not much they can do. I mean, 35, that's even worse. The Court of Justice, we've doubled the number of judges in the general courts, and it's a bit busy. If you add, again, 20 more judges, what are they going to do? So big questions will have to be asked, but the political leaders should have really, how to put it, not colloquially, should have guts to do it and face the reality that this is a very important moment for the EU and Europe as such.
Thank you.
Yeah, just briefly, I mean, a very interesting case is Moldova, because it appears that 85% of the citizens of Moldova have Romanian passports, so they're already EU citizens. And so the question of integration of accession is very peculiar because for that reason. I mean, the broader underlying issue may generally be what does the EU stand for? What is its identity? I mean, is it here limited to safeguarding judicial independence? Very interesting was here the case on the regulation 2020-29-2, the Hungary and Poland cases, where the court essentially said no EU funds without accountability, no accountability without the rule of law, no rule of law without judicial independence. However, the question which that raises is what happens when EU financial interests are not at stake? And when you talk about the rights of refugees, of LGBT groups, of other vulnerable groups. And so here the issue of what does the EU stand for also geopolitically is of some significance, and that raises the question, how can you, is it possible to distinguish judicial independence from these broader questions?
Regarding the EU accession to ECHR, I will discuss it in 2 weeks in Liverpool at a conference organized by the university. So I don't have the full answer yet. But if I read the 2014 opinion of the Court of Justice, one of the problems was that the Court of Justice did not really want to give power and to be scrutinized by anyone from the outside. Which brings me to one of the mentioned already, Dimitri Koshenov paper, rule of law as a tool to claim supremacy in the EU. Those might be, battle between, I don't want to say two boys, two courts. So I don't know if the accession at the moment will be able to change anything if the Court of Justice just doesn't want to apply the Court of Human Rights rulings. And I can imagine that there might be reasons why not to apply a ruling in a given case. The thing is, they did not even mention it, like they as if it didn't exist. I think if the accession was about to change something is to avoid such situations when the Court of Justice just doesn't see the case of Strasbourg. When it comes to the enlargement question, I'm not the expert, so I'm going to comment on that. I will, since I'm based in Budapest, I will be looking at a Hungarian commissioner and checking how he behaves and what is his agenda on the enlargement, because that might be interesting for all. But since this commission is almost done, meaning the elections are ongoing, we'll need to see what happens next.
So yeah, on the associations point. So yeah, I think they were instrumental because they brought a lot of cases to the national courts, which ended up to the ECJ. And this is because these people are under a lot of pressure. So whatever we read in RS judgment and all of this Eurobox and so on, it's true. If you do not respect the rulings or disobey the rulings of the Constitutional Court, this is a judicial offense. So you can, end up, quite bad. And actually what happened, and I didn't have the time to mention that, but there are varied reactions from the lower courts. The lower courts in Romania are really friends of the EU judge, most of them at least. And after the Constitutional Court said, do not look at these reports anymore and do not look at independence of the judiciary, look at our judgments. Some of them said, to hell with it, I'm going to push for preliminary reference to the ECJ. They were prosecuted and after well, suspended and stuff like this and investigated, let's say. And following that, when they were cleared, they changed their approach and stopped referring and stopped, and followed the party line. Other guys immediately changed their approach. So you had various approaches from the national court. So these associations, obviously, since they represent their very freaked out members, they were pushing out for all of this. Now, one point is that I have in front of me a very recent case, which is 5323, again, Asociația Forumul Judecătorilor, which asks a question about the practice that there is there at the highest court, so the High Court of Cassation and Justice, to ask for a special interest for these associations to have in order to introduce claims. Now we'll see how this evolves, because it is it's pending now with the ECJ. But they again question whether this practice is against 19, 12, and 47 of the Charter, basically. And on the enlargement question, my personal worry is what happens right now with all of rule of law backsliding or disaster, or however you want to call it, because I am worried about, and this is a point not necessarily made by me, but Kelemen and everyone kind of makes this point about the infiltration of these bad guys in the European institutions themselves. And I'm not talking only about the commissioner level and stuff like this, but I'm talking about the public servants, right, that come with this baggage of, following corrupt or whatever type of processes, because I do not think we are in a position to say we're safe from that, we're in the spheres, and this cannot happen. They're coming from the member states.
I will start from the question about enlargement. On my opinion, whether it is decision guided by geopolitical considerations, it also needs to take into account the level of preparation of the countries, the public administration. In the meantime, so throughout the years, the European Union has developed a huge amount of acquis in different fields. And having followed most recently the first dialogue between Albania and the European Commission, Albania was quite good on the chapter of the rule of law because of what I discussed, but on other areas, the system is lagging behind, especially in terms of producing new legislation, but also adopting new legislation, but also implementing it in practice. For instance, just to give you an example, there was a chapter, not a chapter, but one of the topics of the discussions was on the right to property. So the right to property, of course, it's tangible property and intellectual property. Intellectual property was 0. And of course, there was a lot to say on the institution of properties after communism, etc. So this is just one area where there is a need, whether there is a politically driven decision to enlarge or not, one also needs to take into account some basic level of available legislation that must be in place, also to ensure mutual recognition. So it was mentioned at the beginning, that's one of the benefits of membership for both sides. On the question of what happened to the 60% of the vacant positions. Since the beginning, the idea was that the number of the judges that would leave, or the share of the judges that would leave the system, would be replaced by the share of new judges that would enter the system. The problem was that the vetting gestage, the process, started from the judges of the higher court. So the first judges to leave the system were Constitutional Court and High Court that remained could not operate for several years. And of course, you cannot replace that with judges that are entering the system from the School of Magistrates. So the way judges enter the system in Albania is through a school, it's a 3-year training, and so it's not the same. So, but part of the whole reform was also the revision of the judicial map. So basically, since there were courts relocated, so the most busy courts were Tirana and some other cities. So the new judicial map that was adopted in January last year foresees that from 22 courts, there are now 12. There is just one court of appeal. So the remaining judges are concentrated in fewer courts, but offices for the purpose of access to justice, ensuring access to justice, offices are left where the, it's not branches, it's offices are left in the existing courts for people to file their documents and requests, etc., that then are transmitted to the proper courts in those fewer cities. And just one final comment regarding what you mentioned as the failure of conditionality. Maybe it's too soon to measure whether the reform has been successful or not. I was reading a recent survey by the World Bank based on interviews of citizens in Albania, and it was interesting to see how on the question of has the reform been successful or not in terms of fighting corruption, etc., how responses were more negative when they were, so two groups of people were interviewed. What is your perception and what is your experience? So perception result was more negative than the experience one. So there is still maybe some prejudice in that sense, but at least one of the results of that survey is that people who actually used the system in these years have a better experience as to the success of the reform compared to just a perception response. Thanks.
Right, any further comments, questions or anything? Just occurs to me to wonder what happens when the number of acceding states becomes equal to the number of countries in the Council of Europe. The two systems coexist.
I don't see that.
Right, well, I think, Yolanda, we're a bit early, but I think that's it. Thank you very much.
Thank you very much to you for chairing 2 sessions today. Thank you very much to all the speakers and to everyone who remained until now. There will be, okay, Iris is saying yes, a drinks reception.
Sorry?
There is a drinks reception now. I think Carmel and Iris are bringing the necessary here.
Oh, here.
It's a work meeting, right? It's a work
Thank
meeting.
everybody very much.
It was.
It's a work meeting.
Good.
Thank you.